I believe that is.
Okay, sir, I just need you to unmute, please.
I did. I unmuted it.
Great. Can you tell me your name, please?
James S. Drysdale.
Okay, we're on the record now in People versus Drysdale. This is file number 256949. The record should reflect Mr. Drysdale's appearing today by video by prior approval of the court. If I could have counsel put your appearances on.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Drysdale.
And Mr. Trush, can you tell me the status of this file here this morning from your standpoint?
Yes, Your Honor. We are in receipt of an offer that we would intend to take advantage of today. An offer has been extended to reduce this from a retail fraud first degree to a retail fraud second degree. So reducing it down to a 1-year misdemeanor. We would seek to take advantage of that.
Mr. Rolla?
Actually, Judge, it's an added count to, but I understand what Mr. Truce is saying. Added count to of retail fraud second degree, contrary to MCL 75356D as an A. That's a 1-year, $2,000 misdemeanor with upfront restitution at or before sentencing in the amount of $1,095.01.
All right, and Mr. Trush, are we taking the plea to the factual basis for count one?
I mean, in terms of the dollar amount, frankly, we're going to stipulate to what's in the report. Mr. Drysdale, I don't think knows the actual, I don't think he has independent recollection of the actual dollar amount.
Okay. All right, Mr. Drysdale, were you able to hear everything that was just said?
Yes, Your Honor.
And have you had adequate opportunity to speak with your attorney about this plea agreement?
Yes, not about the funds, but yes.
Okay. And did you want to go forward with that agreement here today?
Yes.
Can you raise your right hand, please?
Yes, I am.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Mr. Drysdale, are you currently on any kind of probation or parole?
Just probation. No, I'm not on nothing.
Okay. And as the lawyers indicated, the maximum possible penalty you could face for this lower charge of second degree retail fraud is up to 1 year in jail and or a $2,000 fine. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today?
I guess I'm guilty. And I surrender.
Right, I'm going to go through a few things with you with regard to your rights. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes.
And do you understand that you're going to be giving up and waiving all of those rights by pleading guilty and you won't have them anymore?
I'm going to let my attorney answer that for me.
Well, I need you, it's important that you understand that. And so by pleading guilty, all of those rights that I just mentioned are going to go away, including the right to have a trial.
Oh, okay.
Do you understand?
Yes.
Okay. Also, if you wanted to try to appeal the plea that you're making here today or get this your plea reversed, you would have to ask for the next higher court up, which is the Court of Appeals, to hear your case. They could say no, and then that would be the end of that appeal. Do you understand that?
Yes, I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
I'm just surrendering, yes.
All right. Back on December 2nd of 2025, is that the date that this occurred on?
I'm not sure, sir.
Do you have any reason to doubt that that's the correct date?
No, I don't.
On that date, did you go into the Walmart store here in Gaylord?
Yes, I did.
All right, and I guess Mr. Trush, can you, I'm not sure exactly what the factual circumstances were based on the information here.
That's certainly. So Mr. Drysdale, while you were in the store, did you take some items and change the barcode on them?
Yes, I did.
And you changed that barcode with the intention of reducing the price of the item?
Yes, I did.
And did that happen once or on more than one occasion?
I don't recall, but I know it happened that time.
So I think that would establish a basis, and again, we would stipulate to the report in terms of a total loss of $1,206.90.
Mr. Rolla?
Did we get the information that that was the Walmart here in Otsego County? And if that's the case, then the people are satisfied the court has sufficient factual basis to accept the defendant's guilty plea as to added count two.
Thank you. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None for the people, thank you.
I'm aware of none, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Defense is satisfied.
Thank you. Mr. Drysdale, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. That hearing is going to be in person here in the courthouse in Gaylord, so you'll need to travel here to Otsego County for the purposes of that hearing. And it's important that you stay in touch with your attorney between now and then. Mr. Trush, do you have contact information that you can give Mr. DeLeo for Mr.
I can. I would just request, Your Honor, I know that it's typical for us to set sentencing to be in person. Assuming there's not a recommendation for jail time, would it be okay if you were to appear via Zoom? And admittedly, I don't know if there will or won't be any recommendation there, but assuming there isn't, would that be okay?
I think regardless, it would need to be in person for a sentencing hearing.
Okay, understood.
In this case, so. Okay. All right. So Mr. Drysdale, somebody from the probation department is going to be in touch with you. It's important that you follow up with that when they contact you as well. Okay.
Thank you. Yes, I will.
Okay. Thank you. That's all for this hearing today, and you're free to disconnect at this time.
Thank you. I appreciate your time.
My name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Lauren Madison for the defendant, Mr. Dion, who is to my right.
All right. We have this set for entry of a plea here today. Ms. Madison, is your client ready to proceed with that?
He is, Your Honor.
What are the terms of the plea agreement in this case?
Judge, under this plea agreement, Mr. Dion will plead guilty to 3 counts of failure to pay child support with a habitual second. And the state is offering a sentence agreement for a delay of 11 months. During that time, he must pay as ordered every month. If he's able to reduce his arrearages to $18,000, then he can be sentenced on 1 count of attempt failure to pay child support. If he's able to reduce his arrearages to $0, then he can plead guilty to 1 count of disorderly person. And the prosecutor agrees to dismiss count 4.
All right, Mr. Burke, is that a correct statement of the offer by the people?
That is correct, Your Honor. Yes, thank you.
Okay. Mr. Dion, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes, sure, I guess.
I don't want you to guess. If you need more time to talk to her this morning, I'll give you an opportunity to do that.
I mean, I don't think that I think this is the only deal that they could come up with, so we can continue.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Mr. Dion, are you currently on any kind of probation or parole? All right. And you understand that the maximum possible penalty for each of these 3 counts as a second habitual offender would be up to 6 years. Do you understand that?
Yes, sir.
With that in mind, what is your plea to each of those counts here today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights,
Yes, sir.
and you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then you wouldn't be able to go any further with that appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to these charges because you are actually guilty?
Yes, Your Honor.
Okay. And there are three. Ms. Madison, is the plea going to be to counts 1 through 3?
That's correct, Your Honor.
Okay. So, Mr. Dion, between July of 2019 and February of 2020, were you subject to an order here in Otsego County that required you to make child support payments?
Yes, sir.
And were you aware that you were subject to that order?
Yes, sir.
Did you fail to make payments in the amounts or at the times required under that order?
Yes, sir.
And did that also occur during a period between October of 2020 and January of 2021?
Yes, sir.
And then did that also occur between March of 2021 and January of 2023?
Yes, sir.
Okay. Had you previously been convicted of the felony of interfering with electronic communications here in the 46th Circuit back in 2016?
That should have come off my record because I completed the drug court program. It was 7411, I think they called it or something. And upon completion of the drug court program with Mr. Abe Cruz, it was supposed to be a high court misdemeanor, to my understanding.
All right, Ms. Madison?
Thank you, Your Honor. I was not aware of this until this particular moment. I don't know if the state is willing to amend the plea at this point. So there's not the habitual second.
In court last time, I said that there's no reason I should have an habitual felony because I've mentioned me completing the drug court program.
Did that actually result in entry of a conviction to a lesser crime?
When I got sentenced, yes, that's what I signed the paper was for a lesser crime.
Mr. Burke?
Your Honor, my thought would be based on what the defendant's saying. It sounds like he maybe had a couple different charges. 7411 is for drug charges. It looks like the conviction is not even, it has nothing to do with a drug conviction or drug issue. So, I mean, we could certainly look into it. If the court's going to schedule what I refer to as a delayed sentence hearing, which is a hearing about 30 days out, that will result in the court placing the defendant on a delayed sentence per the plea agreement, then we could certainly look into that. And then if there truly is a felony conviction for 2016, then the court can certainly take the factual basis for that at that time. If there's not, then the people would certainly move to dismiss that hab second. I'm just not sure if the court is going to schedule a delayed sentence hearing. Some courts will place the defendant on delayed sentence right away after the plea. Some courts schedule those matters out 30 days because the court wants to see a PSI first. So I'm not quite sure how this court does it, Your Honor, but if there's a possibility of maybe scheduling a delayed sentence hearing and about 30 days out, we could certainly look into that at that time.
Okay. So I think that's a good suggestion. Do you have any objection to
No
that?
objection.
So the way we're gonna handle this, because Mr. Dion, I mean, there's a very detailed legal framework for when past convictions can be used for purposes of habitual offender enhancements. In your case, it's either gonna fit within those or it's not. It should be a fairly simple issue. So Ms. Madison, I guess your client's the one saying it shouldn't count, so I'm gonna put the burden on you to look into that. If there's a statutory basis for to eliminate that habitual enhancement, then I don't think, I think the prosecutor would have to take it off.
Yeah.
So I'm gonna place that on.
And we certainly would, Your Honor, of course. So.
Yeah, right. So we'll go ahead and schedule this. And Mr. Burke, I do generally set him for a delay sentence hearing later after a PSI, and I have a PSI prepared and everything. So we would have been doing that anyway. So it's not going to result in any kind of delay to the case. And then we'll address that issue. Mr. Dion, your attorney is going to look into that for you. And again, if it doesn't apply, then we'll take it off of there. But it may, because there are circumstances where you can have, a conviction not be considered for the public record, but it still can be used as an enhancement, and that may be it in this case. But again, your attorney will look into that for you. So we'll set this for a delay of sentence hearing. You're going to check in, Mr. Dion, with Mr. DeLeo here for probation before you leave today to set up a time for a pre-sentence interview, and then just make sure that you stay in touch with your attorney. Okay. Mr. Burke, anything? Yeah.
I was gonna say, just for the record, I just want to make sure that the court is aware that people are satisfied with the plea as well as the factual basis. The people are satisfied with the court has complied with the court rules for taking the plea. So I just want to make sure the record is reflective of that.
Yeah, thank you. I got sidetracked there from my usual colloquy, so I appreciate that. Ms. Madison, are you satisfied with those matters as well?
Yes, Your Honor.
All right, so then for the record, the court finds the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that Mr. Dion is guilty of each of these charges. The court will accept a guilty plea as to all three. And again, Mr. Dion, just make sure you stay in touch with your counsel. Okay.
Okay.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
And Your Honor, is one last thing. I apologize. Do we have a date and time for the delayed sentence hearing, or is the court just gonna schedule it and notice it out?
Yeah, we'll notice that out. It should be in about 30 days. And if you want to appear remotely for that, I don't have an objection to that.
That sounds great, Your Honor. Thank you. I'll let the Lansing office know. Thank you very much, Your Honor. Appreciate that.
All right. Thank you. That's all for that hearing. The podium there. Thank you. The record should reflect Ms. Cornett's present here in the courtroom today. Mr. Trish, can you tell me the status of this file?
Yes, Your Honor. I've had discussions with the prosecutor, and I've also had discussions with Cornett. The prosecutor is not offering a reduction here. After going through the various different options and potential outcomes with Ms. Cornett, we would be making an admission as charged.
All right. Ms. Cornett, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Cornett, are you currently on any kind of probation or parole? And you understand that by pleading guilty to failure to stop at the scene of an accident resulting in serious impairment or death, that is a felony that carries with it a maximum possible penalty of up to 5 years and or a $5,000 fine. With that in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights. And you understand that you're going to be giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. You understand that? Has anybody threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea? Are you pleading guilty because you are guilty? This happened back on October 20th of 2025. Is that the correct date? On that date, were you operating a vehicle on North Ohio Avenue here in Gaylord? And is there some type of accident?
Yes, there was.
Okay. And did you fail to immediately stop and stay at the scene of that accident?
I did stop. I didn't stay.
Okay. And Mr. Trush, is there any factual dispute about whether there was a serious impairment or a death here?
So, Your Honor, we would indicate, we have medical records from Otsego Memorial Hospital that indicate that there was an injury to the
16-year-old's fracture, I think.
yeah, a fracture to the tip of the fibula. And at least from the records, it would appear that he was in a walking group for some time. It's
Okay.
not clear how much time.
All right. Again, are you disputing whether there was that would qualify as a serious impairment under the statute?
We would not.
Okay.
We would agree.
All right. Mr. Roll, are you satisfied with the factual basis?
Just so there's no confusion, and again, the defendant did indicate to the court that she stopped, but she didn't remain to verify that the person was injured. She stopped, asked a question, and drove away.
Okay. I think that's the testimony.
And again, I just want the record to be clear that way, so we don't, if we have to deal with it at a later time, I don't have to try and indicate that the plea wasn't knowing and voluntary. Thank you, Your Honor.
All right. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Aware of none.
Are you both satisfied that the court has complied with statute and court rule in taking of this plea?
People are satisfied, the court's compliant. Thank you.
Defense is satisfied.
Ms. Cornett, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea today. You're going to meet with Mr. DeLeo before you leave. He's from the probation department. They're going to set up a time for a pre-sentence interview, and we'll schedule this for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important between now and then that you stay in touch with Mr. Trush. Do you have any questions? Okay, thank you. That's all for today.
Your Honor, if I may, I would suggest to the court setting a little additional time for this sentencing may be appropriate. From my discussions with the prosecutor, I think it's likely that there's going to be at least one, maybe two victims who would wish to allocute. And I would indicate, I think there are some things that are factually in dispute. Again, I don't think it changes the plea, but I do think there are some things that will be in dispute.
Okay, thank you. I appreciate that. That's up on that.